Employment Roundtable podcast is produced by the GableGotwals law firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel. Welcome to the Employment Roundtable, where we provide you with the perspectives and information you need to make wise employment decisions for your employees and your organizations. I'm your host, Talitha Ebrite, and today we're here with Holly Cole, Director of the Equal Employment Opportunity Commission in Oklahoma, and my GableGotwals partners, Ellen Adams and Paula Williams, about the second of our three-part series relating to the intersection between employment and health. This episode is focused on general employee parenting issues, including pregnancy, nursing, and parental leave. So the last time we met, we discussed some of the protections, the federal protections available to caregiving employees becoming a new parent, whether as a result of pregnancy or of the pregnancy of an employee or their partner, or through surrogacy, adoption, or fostering, implicates many of those caregiving issues that we discussed previously. But it also introduces a number of other issues employers need to consider. So Paula, starting with you, because we discussed the Americans with Disabilities Act and the Family Medical Leave Act in our last episode on caregiving, can you tell us a little bit about what protections those acts provide in relation to pregnancy?
Yeah, so we have a number of acts that protect pregnancy, and I'd love to cover FMLA and ADA, but let's start with FMLA. So under FMLA, we need a serious health condition if someone is taking time off for their own medical leave. And pregnancy and recovering from childbirth is a serious medical condition under FMLA. So if you're an employer with 50 or more employees, in a 75-mile radius, and you fall under FMLA, pregnancy and childbirth are going to qualify for that leave. But employees may also use FMLA leave when a child is first placed with them for adoption or even foster care. And that purpose is to bond with that newly placed child. They can also use FMLA leave, before the adoption takes place. They can use it for things like counseling sessions, court appearances. They could even use that time to travel to another country to complete the adoption. So FMLA can apply to those scenarios as well. FMLA can even apply to a surrogacy arrangement. Under FMLA, the worker has to be legally and permanently assuming responsibility of raising a child as his or her own, and surrogacy would qualify there. Now, with the Americans with Disabilities Act, pregnancy alone is not a disability. But as I know the women on this podcast are well aware, during pregnancy, you can develop any number of conditions that qualify as a disability, right? So I was lucky enough to have gestational diabetes during all three of my pregnancies. Those young men are so lucky to be in the world. And when an employee has this condition, they may need to have an exception to a food or drink rule, to have a snack or water at their desk. They may need to have short breaks after a lunch period in order to check blood sugar. And so that's an example of a disability that someone may develop during pregnancy. It's not so temporary that it wouldn't qualify under ADA, and it would require a reasonable accommodation as long as it didn't present an undue hardship. Now, there are some aspects of pregnancy that may not be covered by ADA and don't actually result in a disability. And I'm going to be frank here, but when I was pregnant, I needed to go to the bathroom way more than usual.
Same.
So we're going there today. Not to the bathroom. We're going to the topic today. Okay. I'm never going to be invited back. So even though needing to use the bathroom a lot, it wasn't a disability. Other than the fact that I felt like I had a bowling ball sitting on my bladder all day. And so there were still some parts of pregnancy that may not be covered by ADA. And that really led to the Congress passing the Pregnant Workers Fairness Act. And that was just passed earlier this year. And it really interplays with the protections that we see under ADA, but it's brand new and takes effect later this month. And Holly, I've read some of the EEOC resources about the new act, but I know it's brand new. And I'm wondering if you have any insight into that new act and what it might mean.
I do. So the Pregnant Workers Fairness Act, like Paula just mentioned, it was just signed into law at the end of December of 2022, like tail end of December. And it does take effect on June the 27th, 2023. So that's important for employers to keep in mind. And because it's new, I don't have it memorized yet, so bear with me because I know I have a lot of stuff memorized, but not this one yet. So bear with me. I want to read this because I want it to be really really clear what this law is intended to provide for. So the PWFA, Pregnant Workers Fairness Act, requires a covered entity, and that's defined as an employer with 15 or more employees, so that mirrors Title VII, to provide a reasonable accommodation to a qualified employee or applicant with a known limitation related to pregnancy, childbirth, or related medical conditions, absent undue hardship. So that's going to sound like familiar language from the ADA, right? But as Paula alluded to, there's this gap with the ADA that pregnant women who don't have gestational diabetes, or they don't have a disability or medical condition that rises to the level of a disability, they might not be entitled to an accommodation under the ADA. So this law is designed to close that gap to make it really clear when employers have to provide an accommodation. And so keep in mind that any other kind of pregnancy-related discrimination issues, other than accommodation, are going to be analyzed under Title VII, like they always have been. So it's going to be sex, female, and basis of pregnancy, right? So, or the issues would be pregnancy. So this really is a narrow law designed to provide accommodations for pregnant women. And I want to highlight that there's 5 prohibited practices to keep in mind. The first one is denying a reasonable accommodation to the known limitations of a qualified person. So denying it absent undue hardship, that would be a violation. The second one is requiring the employee to accept a reasonable accommodation without going through the interactive process, like you do in the ADA. That's basically a forced accommodation. And then third, denying some other employment opportunity just because the employer is going to have to provide that accommodation. And then the fourth one would be forced leave. So that would be requiring the employee to take leave, whether that be paid or unpaid, if that's if there's another accommodation that could accommodate them. And then finally, taking any other adverse action regarding the terms, the conditions, privileges of employment against that qualified employee or applicant just because they've requested a reasonable accommodation. So that almost sounds like a retaliation, provision. So that's very high level about the prohibited practices. And again, if you check out EEOC.gov, I know you all are familiar with me saying that, but there is a guidance that's called "What You Should Know About the Pregnant Workers Fairness Act," and it's got some best practices for employers. So more to come on that. We're going to start taking charges on June the 27th for events that alleged discriminatory events that happened on the 27th or after.
Great. Thank you so much for that introduction. So, Ellen, now I assume that when new parents return to work following maternity or paternity leave, protections for their ongoing parental caregiving responsibilities are generally governed by the ADA or the FMLA frameworks that we discussed during the last episode, and probably more likely the FMLA. But are there additional protections for nursing mothers? And assuming that there are, could you please walk us through the federal statutes and regulations that come into play for nursing mothers and what they require?
Sure. Well, historically, the Fair Labor Standards Act and the Affordable Care Act have kind of approached nursing mothers when they're returned to work, and the protections are for up to a year after a birth at the federal level. There's a reasonable break time that's permitted, and the reasonable break time also needs to be in a space that's suitable for someone to nurse or pump, depending on their situation. So recently, with respect to federal legislation, they've passed another law that expands those protections away from just those that would be covered under the FLSA to extend to exempt workers. So when we're talking about exempt, non-exempt, those are classifications that largely are understood in the wage and hour context. So it's just, for our purposes today, it's expanding the umbrella. So whether you're an exempt employee, which we're typically going to be salaried, or a non-exempt employee, which are typically hourly employees, both classifications and categories are going to be entitled to take reasonable breaks as often as needed to express breast milk at work. And those breaks are to be uninterrupted, and employers can't discriminate against employees for taking those breaks. So if you pay other employees for break time, you need to similarly pay employees who are using their break time to express breast milk while at work. And then the location, you need to make sure that it's an appropriate space. So you can't tell someone to go use the bathroom stall. That's not going to cut it. It doesn't need to necessarily be a designated nursing room, but it does need to be a designated space that's private. So those protections exist up to a year following the birth of a child under the federal law. There are states that have more expansive rights for nursing mothers that go beyond a year. So just not in Oklahoma, but in other states, be aware, particularly if you've got other employees, that those state laws can differ. And then with respect to remote employees, it applies the same. So just because someone is working remotely, you can't say you don't get break time because you're alone. They get the break time too. And this should be obvious to everyone, but I'm going to say it anyway. You cannot require a remote employee to be on camera during their break time. So,
wow.
Just to be clear, not permitted.
I'll keep an eye out for that one.
Yes. Uh-huh.
That's great. Well, thank you so much for that, Ellen. And just thanks to all three of you. I especially appreciated learning about the new act, the Pregnant Workers Fairness Act. I think we're going to see some interesting stuff coming out of that, and so that's great. And thanks to all of you for listening to the Employment Roundtable. Please join us next time as we continue our 3-part series about the intersection between employment and health. The Employment Roundtable podcast is produced by the GableGotwals law firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel.